Good afternoon, everyone. Freedom Sao is my name, and first I would like to appreciate Dr. Aura and the entire follow-up team for the invitation and the opportunity to present this paper. We shall be presenting on financing access to justice, exploring the justification and the alternatives to such financing in the context of the COVID-19 pandemic. I will lay out the background of our paper and the key parameters that we are seeking to explore, and thereafter I will invite my co-presenter, Mr. Mtembei, to come and continue. The structure of our presentation is as displayed on the screen. We'll start with the introduction, then the current funding framework for access to justice, implications of the COVID-19 on access to justice funding, access to justice and development. This is the link between justice and development. Then we'll also explore the financing alternatives and recommendations, and then conclusion. Our paper seeks to demonstrate why optimal financing to justice is a priority whose implementation has a spillover effect on development. As you are aware, access to justice is a key tenet to justice and to the rule of law. This paper shows the state of funding by the government, that is through the judiciary, the budgetary allocation, and the funding set aside in the Legal Aid Act. Maybe we can go to the next slide on the current funding framework. I'll discuss the current funding framework to the legal justice system. And the current funding framework is first premised on our Constitution under Article 48, where the state is obligated to ensure access to justice for all. The Legal Aid Act 2016 was enacted in response to Article 48, and the Act establishes the National Legal Aid Service to mobilize and manage resources for legal aid. Section 29(1), the Legal Aid Act, establishes the Legal Aid Fund managed by the National Legal Aid Service. The fund is yet to be operationalized, hence a setback in the financing legal aid. When you look at the section 29(1), it shows the sources of the fund as indicated on the screen, where we'll see money is allocated by Parliament for the purposes of service, any grants, gifts, donations, and loans, or other endowment given to the service, such funds as may be vested in or accrue to the service in the course of or exercise of the powers of performance of its actions under the Act. Then also monies from any other lawful source accruing to the fund. The fund is yet to be operationalized, hence the limitation of financing in that aspect. Then also when you look at the financing of the judiciary, it is drawn from the consolidated fund, and that is provided for under Article 173 of the Constitution. This form of funding is from taxpayers' funds, hence difficult to draw more funds from the public during these harsh times, especially due to the COVID-19 health issue. The judiciary has therefore faced a budget reduction due to this effect. I'll be inviting my co-presenter, Mr. Mtembei, to touch on the other financing alternatives, access to justice and development, and also the implementation of COVID-19 on funding to the access to justice. Welcome, Tembe.
So I will not take long. I think our time is almost up. So on the implication of COVID-19 on access to justice, I'm just trying to link this to financing. And the point here is that as a result of COVID-19, there is a negative effect on funding access to justice. So the first point here is that COVID-19 has strained government resources. And during this time, we find the government seeking to prioritize funding to what is deemed important. As to whether the government would deem access to justice something that is important during a pandemic is another question. And this will be informed by the understanding that the government has on the importance of access to justice. Now, in the context of a pandemic, the government may want to spend on what is considered important or what is considered critical in the state at the moment. So if there is a limited understanding of the importance of access to justice, equally there will be limited funding or limited prioritization of access to justice financing. That is why we have seen budgetary cuts on the judiciary and we have, this is in the public domain, the judiciary has in the recent past faced financial challenges, and this has an implication on the realization of Article 48 of the Constitution. I will now look at access to justice and development briefly. This is a wide topic, but because of limited time, we may not be able to delve into the details of the theories underlying this. But I wish to state that access to justice is linked to national development in a significant way. If we have enhanced access to justice, there is a direct effect on improved development of the nation. And we are looking at development not in the limited view of economic development, but in a wider perspective. Now, this has been explored in various readings that we've set out there. But importantly, there is the writing of Amartya Sen on development as freedom. You could read this more on how development is understood in a wider perspective. Now, development has been defined variously, but in this paper, we look at development beyond economic development, and we are saying that the realization of access to justice has an impact on development. And if the government gets this kind of understanding, then they will see the importance of prioritizing financing of access to justice. And the argument here is that the government has adopted a narrow view of access to justice, going by what we see in terms of financing the justice sector and financing what would have a positive implication on access to justice. So that there is need then for policymakers to adopt a different perspective. And this paper makes such argument to persuade policymakers to see the importance of financing access to justice in a more significant way as something that will have a spillover effect on development generally. So access to justice is a tenet of the rule of law and helps to convert legal guarantees into reality. There is a lot that is provided in the law, and when the legal environment is guaranteed, then there is a lot that will happen in many other sectors, including the business sector. So the question then is, in the face of constrained resources, in the face of limited resources, competing needs, and right now we have a pandemic that the government has to deal with as a matter of urgency, and there is still the obligation on the state under Article 48 to provide access to justice for all. So what options are available to the government, considering that we may not be able to get more from the public coffers? Taxation is at an all high, and I'm sure citizens do not wish for more taxation. We have felt the pinch. And then how much are we able to get from the public funding? So you find that it is limited, and that is why we are exploring alternatives and saying that in the realization of the obligations of the state under Article 48, the state can explore alternatives, and this paper outlines and several alternatives, and which will be discussed in detail in the final paper. But just to highlight, we argue that drawing funding for the operationalization of Article 48 from the Consolidated Fund would be one of the alternatives. Currently, the National Legal Aid Service has a fund which is established under the Legal Aid Act. And this fund is yet to be operationalized because it is then left to the political will of the government to ensure that this happens. But if this fund was allocated to the judiciary, and then the judiciary undertakes all this as it would other administrative services of the judiciary, then there would be more independence in the funding, and this would help in the realization of that provision. Now, the other alternative that we are exploring is the strategic and innovative involvement of the private sector. Now, the private sector is not obligated in the law in matters access to justice, but the state can strategically use avenues to bring on board the private sector to contribute to the financing of access to justice. Now, this may involve use of incentives. It may involve maybe the CSR framework and many others. The other option would be use of public-private partnerships. Now, there is the Public-Private Partnerships Act that provides a framework within which such initiatives can be pursued. And lastly, we can actually realize more if we have a structural and strategic involvement of the civil society. Now, currently, the civil society is operating in an uncertain legal environment because the law is not very clear. The Public Benefits Organizations Act is yet to be fully operational, to be actually put into effect despite having been enacted. And this was meant to improve the environment in which the civil society operates. So the argument here is that if the civil society is operating in an environment that is legally doesn't have impediments like we have currently, then we may realize more from the development partners. I think that is the last slide, and those are the alternatives that we've explored, and that these ones will be more there will be more detail on this in the full paper. That will be all. Um, Mr. Kayudi.
All right. Thank you, Robert and Frida. At least you are sticking to time, so we are doing good. We shall proceed to our next presentation, and this will be Kevin Muiruri and Florida Musi, and they'll be presenting on the impact of COVID-19 on access to justice, an analysis of the Kenyan criminal justice system in a socioeconomic crisis. Welcome.
Good afternoon. My name is Kevin Muiruri, and I'll be doing a paper as mentioned, access to justice in the COVID-19 period. A proper analysis will be done on specifically the criminal justice system. So there are key things that we are going to address first. The first thing is the rights of the accused within the criminal justice system. Number two, we're going to address the implementation of the Public Order Act. As we are aware, when COVID-19 struck, there was need for amendments of the existing laws so that we can be able to mitigate on the risks that COVID comes with. For example, the rapid transmission of the disease. So we're going to address that, and on addressing the issue of enforcement of the Public Order Act, we are going to measure specifically on issues relating to police brutality. Then the other thing we are going to do is to highlight on issues of how gender-based violence was handled through the criminal justice system. And then lastly, but not least, we are going to share information of how prisoners have been locked out of the access to justice within the criminal justice system because a lot of shift was made towards the virtual court system. So and the other thing will be addressing a comparative study of Canada, the UK, and Australia. So on to the first thing, my introduction. As we know, the criminal justice system takes a clear path in most of the countries, and this applies to Kenya. So the first aspect that comes into play in the criminal justice system is the law enforcers. The law enforcers will actually make an arrest of the suspected criminal. The other thing is investigation. Investigation in the sense that they will investigate the accused crimes that have been said so that they can be able to be taken to court. So the judiciary comes as a major player. This, and lastly, is the correctional institutions, the institutions that, for example, the probation institutions and the prisons. So this criminal justice system, the normal criminal justice system, was affected majorly by COVID-19. So we are going to address that. The research methodology is based on a clear analysis of electronic journals from JSTOR and Google Scholar, and also we are citing cases from the electronic Kenya law reports because, as we know, COVID is something new, and we don't have so many books about COVID-19. So on my first issue on gender-based violence, so the pandemic wreaked havoc on how we deal with our issues. For example, both people in the family, let's say the husband and wife, were forced to stay in the house because of issues relating to mitigation of COVID-19. So when you stay in the house with someone, you have not been staying with him or her a long time in the house, you realize some characters that maybe you hadn't realized in the past. So these characters, some small issues bring about conflicts, and these conflicts majorly affected the women and the children. So the other thing is we realize that the criminal justice system comes into play in the fact that gender-based violence is supposed to be reported to the police, and maybe from there action can be taken. However, you find gender-based violence is reported, but very little action is taken, and in some situations the accused is arrested and then later released. So this becomes a challenge because there is no effective implementation of the rule of law, and in most cases you find that these persons who have been released are going to come back and act in vengeance on the person who reported them. Then the other issue is analysis of the police and how they conducted issues. For example, there was the implementation of the curfew. Normally, the police are not supposed to act while implementing their duties. They're not supposed to act with extreme force, but we saw that they acted in a lot of force. And then during the pandemic, the criminal justice system did not take its natural course, as the law enforcers took law into their hands. The reports made by Human Rights Watch indicated that during the first 10 days of the dusk to dawn, police assaulted at least assaulted people, and at least 6 individuals were killed. So there's a case that was filed by the LSK, and it was a petition between petition 120 of 2020 between the Law Society of Kenya and Hilary Mtiambai in the High Court, and the curfew, the implementation of the curfew was challenged, and it was held that it was unconstitutional because of the events that had followed due to matters relating to the criminal justice system. Then the other thing is the virtual courts were actually being implemented inside police stations, and the police were in charge. So in order for the police to ease their duties or their work, the role they play inside the criminal justice system, they used to force the individuals or the accused persons to admit liability, and basing on the law of criminal, admissibility of a crime is sufficient to maybe convict the accused person. So that was the major challenge. Because of time, I would like to call my co-presenter Florida to continue.
And just to continue from where Kevin has left, COVID-19 saw the introduction of the e-filing court system by the judiciary. And just to speak more about the e-filing court system, the e-filing was introduced. Waiting for you, Kevin. Okay, so the e-filing court system was introduced because, of course, people could not, not everyone could get access to courts, and not everyone could have the chance to take documents to court. So the e-filing system has two interfaces. It has the user interface, which is for us, the litigants and the lawyers in the room, where we upload papers and file the court fees and everything else that we need for the trials in criminal cases. And also, now it also had the judicial interface, where now the judges and the magistrates in court could access the court documents, so that when they are delivering judgments and rulings or mentions in the morning, it's done. But however, the e-filing system came to Kenya is a young nation, and when we compare Kenya with other developed countries such as the United Kingdom and Australia, which are some of the countries we have focused on in our comparative study, you come to realize that Kenya was not ready for this e-filing system, because, as discussed earlier by earlier presentations from Justice Wasilwa and many others, 60% of the Kenyan population cannot access a computer, and even in the 60%, 50% of them do not know how to use the computer. So it was hard for for the Kenyans and for the criminals in this case to use the to use the e-filing system. However, I'll speak about the Kevin is really losing me because I really need him to project. Anyway, in as much as we've criticized the e-filing system, there are some advantages that this system has brought. It has enabled more accountability and transparency from the judiciary, because now you can log into the Kenyan law and the Kenya judiciary and you can access the documents that were filed for the BBI case. And even when they were delivering the BBI judgment, all of us could access the 1,000-page judgment that was given, which is nice because the e-filing court system has enabled transparency and accountability from the judiciary. It has also reduced paperwork in courts because as all of us who've accessed the court systems, the storage units are usually so big. They roll the doors. It's that big. So the fact that there's reduced paperwork, it has made the workload easier. And also we are going to a digital era. There's no need, there's really need for us to have everything online. Then also the e-filing system is good for us because the potential loss of documents cannot be incurred. Cases where the registry loses a file, then now the criminal cannot be brought to court because the file cannot be accessed. So the e-filing system has helped there. It has also expedited the access to justice because the IOs don't need to come to court to give evidence. They just need to upload it on the system and it is seen. The challenges of the e-filing, as presented by Justice Wasilwa, there is challenge in assessment of nonverbal cues, such as the defendant's emotions and the eye movements when they are giving or when they are taking their pleas. You know, there is a stage in courts in criminal cases where there is mitigation. So as a judge, if I cannot appeal to your emotions because I can't see your video clearly, that means there will be miscarriage of justice. And also, virtual court appearances do not allow for proper examination of ill treatment of the accused persons. As earlier stated by Kevin, police brutality was on the rise because police were really mishandling criminals. But now you can't just, if you are arrested for curfew, you can't justify yourself that the policeman was really rough with you because the judge cannot examine your ribs and see maybe they hurt you. And also, as a criminal, when I appear in court and take my plea before a judge who I can see, I'll be very confident. But when I'm standing behind a screen, I'll feel intimidated and I'll also lack confidence in the system that is administering justice. And that means from there I'll go and appeal because I'll feel like I'm not confident with what the judge has said. So those were the challenges that were faced by the criminals in there's also potential threat of cyber attacks because IT is becoming a thing and there are so many graduates of computer science and all those things. The system is still not secure enough to assure data protection, or so the judiciary cannot assure us
that there'll be no hacking or loss of documents online. The fact that we have migrated to digital means does not give us 100% assurance that our documents will be well protected. And with that, I'll move to the recommendations that we'll focus on for the study. And one of the recommendations, with the rise of gender-based violence cases, for example, when you look at the statistics, when you compare 2019 and 2020, okay, 40% of there has been a 30% increase on cases of gender-based violence among families, and also domestic violence. So criminal justice is being miscarried because from March to like June, before the court system, the virtual court system was opened, it means there were cases of gender-based violence that were occurring, and no one was there to help because the courts were closed. So there is need for prioritization of gender-based violence cases, so that at an era where there is mental breakdown and the fact that we are staying at home with people we don't want to stay with the whole time, it is important that we prioritize gender-based violence cases to be heard by the courts. And also another recommendation, there is need to improve the infrastructure in the judiciary, which is going to be a challenge because the judiciary is really not developed. Some cases like Nakuru law courts, there was so much overcrowding until they had to even build a bigger court. And we've seen that in most courts, they had to put up tents outside because the rooms could not be conducive for COVID purposes. So with that, I'll move to comparative study with jurisdictions that have been more developed. And an example is Australia. When you compare Australia and Kenya, Australia introduced the virtual court system in 2018. That is pre-COVID. So by the time COVID came, Australia was ready to handle cases, even if it's not in physical courts. But now when we look at Kenya, there is a lot to be done. Then when you compare with UK, the United Kingdom, by early 2000, they had automated everything in courts. And case filing, fee payments, and all that was done virtually. So there is really need for Kenya to make steps towards achieving that ideal situation of virtual court systems that do not allow for miscarriage of justice. Thank you.
All right. Thank you, Florida and Kevin. I think it's only fair enough that we give them another hand clap. They are law students, so their first time presenting at a conference, and I think they have done justice. We move on to the next presentation, and we shall hear from Onyango Aaron Okoth, who shall be presenting on rendering unto Caesar, protecting the rights and entitlements of interns in the post-COVID era. Welcome.
Thank you so much. Thank you so much for the opportunity. I think I'll just dive into it. But first and foremost, I'd like to give a caveat. I heard one of our colleagues recently just mention that lawyers' presentations are supposed to have cases. Mine only has highlights, but I assure you I'm a lawyer. And also, most of the presentations we've had, ranging from Dr. Auro's presentation about gender to Ronald Kihale's presentation about the ATP, has majorly been derived from experience in teaching, the experience they've had personally in learning. But my presentation is mainly derived from my fear of experiencing the vagaries of internship. So I'd like to invite us all for the next 30 seconds to picture yourself as Bob. Bob is seated in an afternoon in office, tired, just the way you all are. He receives a text message. It's his mother texting him for the 10th time, asking him when he's bringing a girl home. He only recently got onto the graduation list after 6 years in school. After 4 years, his parents thought he had spent the money on slay queens and betting, but he's managed to get himself on the list. They've held a celebration. His whole village was there. He's on his local chief's speed dial, and he's now being invited to all events happening in his home as the chief guests. Keep that in mind as I proceed. So, and meaning to trap him, they asked him, should we pay taxes or should we not? Knowing what they were trying to do, he called them hypocrites and asked for a denarius. And he asked them, holding the coin up, whose face is he? They answered, it is Caesar. And he told them, render unto Caesar what is Caesar's, and give God what is God's. So this is the premise of my presentation. It is about protecting the rights and entitlements of interns in the post-COVID era. COVID has had its vagaries. I shall not belabor them. They have been mentioned severally. And one of the main things we realized was happening during COVID was the downsizing of many organizations, many firms, and that involved getting rid of people who are considered redundant or unnecessary. Unfortunately, interns were the first to go. Firstly, because they were considered unnecessary, which is far from the truth. And secondly, because due to the vague protections interns have under the law, it was easier to show them the door than firing an employee who has an employment contract, which could later on lead to other legal ramifications that employers would rather not face. So who is an intern? An intern is a student or a graduate who has no practical or real-world experience in the labor market, who undergoes a process called internship, during which they obtain practical experience at a job. This is a general definition. There are other definitions, and it is not exactly true, but that shall form the basis of my paper in the third national conference on national aid or legal aid. So, how did we get here? Unemployment is a major issue that every successive regime has faced in Kenya since independence, and it is a problem that only continues to grow. And to put this into context, in 2015, 8,000 people applied for 1,000 slots in the judiciary. And recently, it was announced that over 60,000 people applied for only 560 slots in the judiciary. Unemployment is a problem, and it's continuing to grow. And successive regimes like the Kibaki regime tried band-aiding the issue with the kazi kwa vijana, which later became pesa kwa wazee. And later on, the current regime has tried the kazi mtaani project, which again is not really going to the gist of the problem. Now, why have interns gotten to where they are? First and foremost, interns are inexperienced. We are inexperienced in that we have not had our actual real time in the labor market. We do not know how to value or monetize the labor that we offer. This allows employers to take advantage. We cannot bargain. We are at a lower foothold when it comes to bargaining for our pay, bargaining for our working conditions. So employers take advantage of this. Others might argue, but Bob, you have gone to school, you have been in campus for 4 years. Surely you've known, you have mentors, you've had the opportunity to interact with mentors who will tell you how to handle yourself in the interview room. But to these people I ask, if you were to find yourself across the table from a boisterous person such as my teacher, Evans Ogada, with his voice, and he asks you, kijana, unataka pesa ngapi? All that theory would go out the window. Secondly, there are vague protections for interns under the law. Dr. Gadongo Novembu has tried to insist that there are actually protections and interns are envisioned under the law. He mentions that an intern can be inferred from the Employment Act. He also mentions that the industrial Training Act, I believe, has mentioned interns. He further mentions that the guidelines on socials. I'm sorry. He also does mention that the guidelines for public service have mentioned interns, but in the real sense, these definitions are only inferred, or the existence of an intern are only inferred or borrowed or assumed in these instruments. So, what does the law say about interns, or about protecting? How has the law attempted to protect the rights of interns? The law has, through courts, has established tests. The case of Christina Lopeyo versus Wycliffe Mwatipere. Our courts outlined 3 tests: the control tests, the economic realities tests, as well as the integration test, to attempt to mitigate the effects of a worker who lacks any protections under the law. Now, I shall only highlight the tests. I believe many of us are well acquainted with the tests of employment. And now the control test was enshrined in the case of, not enshrined rather, but it was highlighted in the case of ready-mix concrete, where the court stated that measuring the degree of direct control or direct power that a person has over their subordinate or their employee or their worker can be used to adequately determine whether this person is an employee. The less the control one can exert, and the more the leeway a person has to decide how they do their work, this person is more likely to be an independent contractor, a person who's been outsourced. But where there is a direct exertion of this control, this person is thus then more likely to be an employee. Under the guidelines that I have just mentioned, every single entity in the public service, those are public organizations, government organizations, are required to assign an intern a supervisor. This supervisor is required to elucidate them on the policies and guidelines of the organization, to assign them duties and tasks and the prerequisite deadlines. Going by the definition, or rather the aspects of the control test, the guidelines in itself are envisioning a person who is under the direct control of a supervisor or the organization. Are interns employees? That is for you to say as we proceed. The next test is the integration test. The integration test was outlined in Cassidy v. Ministry of Health, where the court said where work performed by a worker forms the integral part of the type of business performed by the organization, or whether the rules and the policies of the place apply to them, then they are more likely to be an employee. Where the rules do not apply per se, they're only granted a set of rules, but how they do the work is up to them, and they're doing the work as an ancillary part of the operations of the premises, then they are more likely to be an independent contractor. Now, under Vitalis Olieo Komudo v. AAR Health Services, the court stated that the internship agreement highlights that there is an intention to place the intern under the direct supervision and instruction of the supervisor. And usually, interns are actually placed within departments. If you've been to interviews, you're asked department you think you can work best, and your supervisor will be the head of a certain department or an officer of a certain department. This means that you're actually being absorbed into the general area of practice of the organization rather than the peripheral areas. Lastly, we have the economic reality test, and this test basically involves how and whom financial benefits accrue during performance of work. A person, it was mentioned in Carmichael v. National Power PLC, a person who submits and exchanges labor, submits themselves and exchanges their labor for payment is a person who's an employee. But a person who chooses how they do their business, provides himself with the staff and equipment to do work, and can actually suffer loss or financial liability, is more likely to be an independent contractor. We see in Kenneth Kimani Mburu and another Vikibe Muigai Holdings, a hotel was to be built, and the owner, Kibe Muigai, brought in individuals to help him establish his menu and the standards of his hotel. He gave them a place to do their work, instructed them they had to work from there and nowhere else, gave them laptops to perform their duties, provided them with internet. The court stated this level of control over the resources, where and how to do the work, simply means that they were employees and not consultants, not outsourced staff, not independent contractors. With this in mind, we know that during the duration of an internship program, interns are usually provided with a place to do their work. They have the supervisor who dictate how and for how long they are supposed to work, and also the Public Service Commission internship policy and guidelines for the public service spells out the conditions under which an intern is supposed to account for all the tools and equipment they've used during the internship. This simply means that it is envisioned, the government envisions that an intern is supposed to be provided with some tools of trade during the duration of the internship. And the guidelines similarly outline the period during which they're supposed to do their work. All of these tests, the guidelines in mind and the practice on the ground, shows that interns are actually employees and deserve the same rights and entitlements as regular employees. Furthermore, interns actually do, after the prerequisite training, after the supervision, they actually do same, if not more, work as regular employees. How then can we leverage what we already know for economic recovery post-COVID? My proposition is that interns actually provide a pool of affordable labor, more reliable labor, more flexible labor than our peers, some of our peers in this room could provide, with all due respect. That could provide. Let me be specific. Let me go down to nitty-gritties. Now, we offer comparatively cheap labor. How do we offer comparatively cheaper labor? First of all, interns enter the market at an entry-level job. Entry-level jobs generally pay cheaper. We can perform the same amount of work, but at a lower cost, compared to veterans who've already raked in years and years and decades of promotions and have to be paid more. Secondly, interns are less likely to be encumbered by spouses, children. Therefore, the wage bill, when it goes to matters such as social security and the likes, is lower for employers. And lastly, because we are not encumbered, we are more likely to be willing to move closer to places of work, which lowers the transport allowance issues, such as housing allowance that the employer may be required to dish out. Secondly, we provide a more secure labor base. In what way does this happen? When we are fresh out of campus, we have decades of work in us. We have decades of work left in us. This means that if you do absorb me eventually, you can go 30 years, 20 years without worrying about how to replace your workforce. This might be very different from a person who is closer to retirement, such as some people in this room. No fingers pointed, but yeah, we provide a more secure labor base. Some people might dispute this by saying that, Bob, your generation is carefree. You want everything, you don't put in the work, you think you know it all, and immediately after training you'll up and leave. But to those people, I pose the question, if you actually value my labor the way it is ought to be, if you offer my labor the prerequisite value and offer me the proper working conditions, why should I ever leave? Why is there a person paying more for the same work I do for you? Lastly, we are flexible. Our colleague mentioned something about him being unwilling, rather, not unable, unwilling to be in a class with his grandson or son when it comes to adapting to COVID, adapting to new technology and new experience. Younger people are more receptive. We're easier to train, cheaper to train, plus we're bringing in all these years, we're bringing in new knowledge into the system. So, with this in mind, it is actually more beneficial to have interns like Bob in your organization. And my recommendation to make this a reality is that firstly, we should expand the government internship program with the view of increasing the number of interns in the public service, which is not only provide the government a cheaper labor force, but ensure that the government has a labor force that is more productive. Secondly, expanding the objectives of the government internship program for providing an opportunity instead of just providing another program where you get in, do your 3 months and get out. It should work on now absorbing these people into the aging labor market, into the aging civil service. Yeah. With those remarks, I rest my case and request you all give Bob a job and pay him well.
In the spirit of Pan-Africanism and my roots as a Nyerian Kikuyu, or what my grandfather would call Odoire wa Mogikuyu, I like to tell people that my name is Wagare, not Wangare. But since I'll also be making my presentation in the Queen's language, maybe we can let that slide. So you can already tell that I have a particular hate for whitewashing of African values. And in the same way, I have a deep hate for science fiction movies. But us living in a world where we have seen the ripple effects of climate change and COVID-19, I feel that I'm already living in a science fiction movie. And that's something I really hate, and I was thinking about when writing this paper. So COVID-19 and climate change, how are they connected? Did one cause the other? Did COVID-19 emanate from climate change? That is something we are not certain about. We don't know for sure. It's theoretical, it's not scientifically proven, but we know that both of these have composite threats. They are the composite threats in our time and continue to affect us. And if not addressed, they still will continue to affect us. They are evolving. They are two distinct, different, distinguished crises, but have evolving science that require both national and international policies to address their cascading and compounding risks. COVID-19 impacted climate change both positively and negatively. Negatively, COVID-19 saw us using masks, PPEs, which ended up in polluting the environment, an increase in the use of electricity, since most people had to work from home, so you had to use electricity, and this saw the increase or rise in the different ways that the environment is polluted, and in turn causes the climate change crisis to aggregate. But in another way, COVID provided us with an avenue to see that we can indeed live in a clean environment and attain climate justice, because people stayed at home and people observed the stay-at-home orders, the lockdowns, the curfews, and we observed an increase in cleaner air in most countries. Of course, this was short-lived because people had to go back to work and these orders were removed. So my paper is rather long, but due to time, I will discuss the parallels that exist between COVID-19 and climate change. There are so many similarities between COVID-19 and climate change, in as much as they are different. COVID-19 and climate change are both deadly and they are both costly. We know that coronavirus has caused immense health issues and complications such as breathing difficulties, and eventually most people have died from COVID-19, and it has raised or caused an increase in it has caused economic contractions and great recessions. This has also been recorded in the Cambridge Business Risk and World Bank reports, so I'm not going to go into that. Climate change has seen an increase in heat-related deaths, malaria, flooding. Kenya is no exception. It's still happening right now in places like Marsabit, and those places are highly populated by indigenous people. So their effects are also largely external and require collective action. The failure of one person to internalize the effects of COVID-19 and climate change leads to collective consequences that are experienced by a larger population of people. And in order to attain optimal solutions to both of these pandemics, we require centralized coordination. There is also a lot of political bias when it comes to COVID-19 and climate change, how to address them, whether they're illusory, whether we are going to attain what we want out of these pandemics. Is COVID-19 going to end? Are we ever going to attain climate justice, or is it monkey business in engaging in ways of ensuring that there's cleaner energy, or people observing the restrictions that have been put in order to curb COVID-19. Both of them are also invisible, and this invisibility makes both COVID-19 and climate change exponential in nature, because for you to realize that you have COVID-19 and for the symptoms to manifest, it takes quite a long time, probably 2 weeks. For climate change, when we start experiencing floods and such things, that's when we realize that indeed the pollution of the environment is costing us. And this difference in the time frame before contracting the disease or the impact of the emissions and realizing the dangers of them is causing them to be exponential in nature. COVID-19 and climate change both segregate the marginalized people in our communities and marginalized countries like Africa, and they also exacerbate inequalities. When COVID-19 hit, the most marginalized and the poor in our communities were unable to access things that are required in order to fight COVID-19, like masks. So most of them died out of this, or they were the most affected. African countries in general emit less than 4% of the greenhouse gases, yet we have seen the patterns, the change in the rain patterns and heat-related deaths mostly affect African countries. Of course, COVID-19 has received drastic and expeditious measures in trying to deal with it, while climate change is still perceived as an elitist issue, something that elites are supposed to deal with. And this is a big problem. Why do we have this difference when you're addressing COVID-19 and climate change? COVID-19 has a lot of saliency. We've seen people broadcasting the effects of COVID-19. Scientists have been brought in to board to explain to the public the effects of COVID-19, and this has influenced policies. There is a lot of policy reaction with regards to COVID-19 compared to climate change because of the saliency that COVID-19 has received. So most people understand how COVID-19 is transmitted as opposed to climate change and its effects, because climate change has spatial variability. There's also the intergenerational dilemma. We know old people are afraid to die. So with COVID and them knowing that COVID can cause death has led old people who mostly populate the policy making bodies and framework making bodies, and this has made them react drastically to COVID-19 as compared to climate change, because as you can see, most people who are actively involved in advocating for climate change, climate justice, are young people. I also I also discussed access to justice in my paper, but most people have discussed that, so I won't go into that. This is provided for in Article 48 of the Constitution, and some cases. Different Kenyan courts have expressed different views on the concept of access to justice. It can either be formal or informal. It can for you to access justice, it may involve both formal and informal justice systems, and it can be procedural and substantive. How is the environment connected to human rights? Article 42 of the Constitution provides that every person is entitled to a clean and healthy environment, and this establishes the relationship between the environment and human rights. Because as I was listening yesterday to Evans, is it Evans or Evans? Evans Ogada, making his presentation. He talked about human rights being interconnected. They are neatly integrated, and environmental rights, environmental protection being a human right, is complementary to the right to life, the right to health, and therefore these basic human rights are dependent on observing environmental protection mechanisms. And the ultimate goal of attaining environmental and climate justice is obviously sustainable development. And Francis Mwangi talked about one of the SDG goals being clean energy. So, yeah. What are some of the lessons that we learned from COVID-19 with regards to climate change or other potential pandemics that may come in the future? What are some of the joint drivers and integrated vulnerabilities that COVID-19 and climate change have that is exigent to the attainment of climate justice? The immediacy and severity. COVID-19 responses have been rapid, and they have been based on the assumption that the spread is immediate, and this has caused expeditious policies being formulated, as opposed to climate change, because it is viewed as a futuristic issue, so it's dismissed and it receives less radical response. We can also learn that early action is good action and late response is bad action. Countries that responded quickly and drastically in curbing COVID-19 and providing these measures and restrictions experienced lower death and reversibility as compared to other countries like the UK, which took longer to impose lockdowns and such measures and experienced more deaths. I also learned that informed early action is better action. COVID-19 saw the revival of the value of expertise because medical practitioners, virologists, and scientists were the main people who are involved in explaining what coronavirus is to the public. So this scaled and broke down the ambiguity that is connected with COVID-19 as opposed to climate change, which most people don't understand. Evidence-informed decision-making or judgments over evidence-free and evidence-based judgments. Evidence-free judgments can be biased. Evidence-based decision-making though good, runs the risk of being technocratic, unbalanced, clunky, and slow. So, what is the middle ground between evidence free judgment and evidence based decision making? It's evidence informed judgment, and this is the main role of science and scientists. We've seen in countries like Germany, where one of the leaders, Angela Merkel, had a scientific background, and this gave her an edge in fighting coronavirus compared to the European countries that neighbor Germany. We also learn from COVID-19 experiences that we should always remain proactive in the face of uncertainty. Many countries have not abided to their agreements towards the temperatures that they should, the temperatures that they agreed on for emitting greenhouse gases, because they've said that it is uncertain whether we follow these measures or not. Do we know if it's going to lead to the attainment of climate justice? Am I the only person who will be observing this and other countries will still be emitting greenhouse gases? But with COVID-19, we did not know the scope of its spread, yet most people came up with policies to curb the same. We also learned that numbers must matter, cost. The major excuse again of most people in the attainment of a net zero greenhouse gas emission target has been the lack of knowledge of how much it will cost. But this has been different when it comes to COVID-19, because countries did not know how much it will cost to curb COVID-19 and support these response measures financially, but they still did it anyway. Also, the numbers matter lives. COVID-19 has received drastic measures because of the reports that we see every day of how many people are dying from COVID. But when we look at the total death toll rate in every country, are we able to know how many people died from climate related issues like heat, stress, malaria? What if we made climate change an issue of life and death? What if climate change was also measured in terms of life and death? Could this help people to come up with better policies to attain climate justice? Can we have stratified and disaggregated data that shows how many people have been affected by climate change, if this is going to spark policies and response measures? So rapid emissions are possible. Rapid emission reduction is possible. COVID-19 has shown us this. I've talked about the effects that the positive effects that COVID-19 had on the environment. So what's the way forward? What can we learn from these lessons of COVID-19, and how can we apply these lessons to our day-to-day lives, even as countries, individuals, and internationally, in order to have a sustainable earth and a green earth? Diana, I believe, talked about strategic litigation, right? So yeah, I won't go into that, but I talked about strategic climate litigation. What can advocates and lawyers do about this issue? Strategically pick up cases that seem to affect the environment and go to courts and strategic climate litigation, transnational strategic climate litigation, which is happening in France, where multinational countries are forced to take up the duty of care to ensure that their companies are not emitting greenhouse gases above the required temperatures. Can we adapt that as Kenyans? I also talked about climate change mainstreaming. We all know what that means, so I won't go into that. And the major way we can attain climate justice is through restorative climate justice. We know that restorative justice is reconciliatory, it's relational in nature, where the person who is causing harm is able to restore the people who this harm was caused to. 5 more minutes, please. Or the the victims and between the victims and the offenders. It's a relational concept between the victims and the offenders. So how can we translate this into climate justice or attaining climate justice? Through measures such as indigenous sovereignty. We know that indigenous people relate well with the environment and the ecosystem, but we are seeing them being moved out of their places or the places they call home, such as forests. I believe Professor Patricia Mbote has written a lot about this, the Ogiek community, and being pushed away from that. And also, the agricultural practices are not GMO influenced. So can we adapt that indigenous sovereignty? Vandana Shiva is an environmentalist. She's also known as the Gandhi of the environment, I don't remember. Talks about the productivist agricultural approach, where she supports agroecology, monoculture, which requires less input of fossil fuels. Can we adapt that? We can also adapt food sovereignty, where we ensure that our forests are the best carbon capture method, and it's the best carbon capture method, and this has worked for Africa for very many years. And recently we've been seeing the cutting down of trees and deforestation. Can we adopt this to ensure that there's sustainability? Gender justice. So we know that most women play a critical role in environmental conservation, but they still remain invisible when it comes to policy formulation and frameworks. Vandana Shiva is quoted to say that seeds are the first link in the food chain, yet women seed breeders are invisible in the industrial model of food production and intellectual property regimes. The roots of food and gender justice lie in keeping seeds in women's hands and recognizing women's knowledge of biodiversity. Restorative climate justice ensures that the untapped environmental protection knowledge that women have is put into account in the promotion of climate justice. As I conclude, we can also employ environmental ethics for climate justice. Socrates talks about human reason as opposed to theology in the creation of ethics in our human lives. How can this relate to environmental and climate justice? Promotion of ethics a positive attitude towards environmental conservation and the attainment of climate justice lies from the grassroots levels when kids are growing up to where we are right now, and integrating anthropocentric, that is human-centered approaches, and ecocentric approaches in conserving the environment. Violation of environmental rights and the creation of an unlivable planet stems from a negative value system. So it is imperative to instill an environmental ethics and standards in order to attain climate justice. We never knew that we would face a pandemic such as COVID-19 to be able to realize the perpetuating effects that such global pandemics have on our human lives. But here we are. COVID has given us that avenue to be able to deal with pandemics in a better way. As I conclude, COVID, as opposed to what most people believe, has not killed ideology. It has cycled it around and immortalized the ability to shift from crisis to opportunity. My parting shot, something that my grandmother would say, and something that has instilled environmental ethics in me and wanted me to seek climate justice. In my pathetic Kikuyu, and I'll translate it into the Queen's language. Arĩa moĩ ruo wa kuona mĩtitũ na mĩgũnda ĩgĩthũkio, no nginya matue matua ma kũgiginyana, na ũgiginyano wao no nginya matũngwo nĩ mbara, no matingĩtigithanĩria kana kũgũagũa, tondũ mĩtitũ nĩ mĩtũrĩre itũ, Irioshito, Thayowito, Naroshiorito. This is a quote by Wangari Maathai, who we all know was a great eco-warrior. Those of us who witness the degraded state of the environment and the suffering that comes with it cannot afford to be complacent. We continue to be restless. If we carry the burden, we are driven to action. We cannot tire. We cannot give up. For forests are our lives. They are our food. They are our peace. They offer us a better tomorrow. Climate change, if not addressed, will continue to cause harm to the environment and eventually our whole existence. Climate action begins individually, as we've seen from COVID, then communally, nationally, and eventually it will influence global perspectives in dealing with COVID-19. Africa is developing. Kenya is still a developing country. Can we come up with policies that will inform other worlds in how to deal with climate issues and attain climate justice, climate smart agriculture? We are seeing roads being built, the northern bypass, the southern bypass. I've not seen anyone question whether there are cyclist lanes that have been included in road construction, because we know cycling also is the best carbon reduction method. Thank you. Think about that.
It is wonderful that we had the previous presenter, because what I'm going to present on really is very related to climate change. And as you know, as we continue destroying our environment, and we are overpopulating and encroaching the ecosystems of other animals and organisms, we are going to have many pandemics in future. So this is just the beginning, and we should be braced for the worst, right? It's good to be always ready for the worst. So my topic is preparing for the next pandemic and the need to reevaluate the NHIF. It is premised on the experiences Kenyans have had during this pandemic that I will discuss as we move on. And the problem that informed my discussion, or that informed my research, it is the exorbitant payments Kenyans have to pay in order to access treatment during COVID.